It's a decision some say really hurts.
The Kansas Supreme Court says the state can limit damages in lawsuits for pain and suffering. The ruling involves a case brought by a Eudora woman. Amy Miller sued her doctor after he removed the wrong ovary during surgery. A jury awarded Miller nearly $760,000. But today, the Supreme Court upheld a lower court decision limiting the amount to $250,000. So what happens now? Eyewitness News reporter Jim Grayway finds out, new at 10.
Instead of protecting Kansans, it places Kansans at risk.
At risk of harm by those who attorney Larry Wall says don't have to worry about high pain and suffering awards if they're sued.
What will happen is the bad doctors, the bad drivers, the bad landlords will be encouraged to move to Kansas because they're going to have low damage awards for their negligence.
Wall represents Charles Morgan and Brenda Pardee of Great Bend. They say their apartment filled with carbon monoxide last January due to a faulty furnace.
Having memory problems and then pain, like numbness, and like shock stabs in my legs, my groin, and my right hand.
Pardee says she has all that, plus partial blindness.
We're not able to work. We can't keep on top of the bills because of that.
Wall says he'd been holding off on a lawsuit against the couple's landlord, hoping the Kansas Supreme Court would do what he considers constitutional and overturn the $250,000 cap on pain and suffering. The Missouri Supreme Court overturned the cap there this summer, a cap that was $100,000 higher than in Kansas. And while the Kansas court ruled 5-2 in favor of the cap, the majority opinion says it's troubling that Kansas lawmakers have not increased it since 1988. Short of eliminating the cap altogether, Wall and his clients agree on that.
The value of the cap today is half the value it was when it was enacted.
Prices go up, and if that doesn't, it's not that someday it's not going to be anything. I mean, we're messed up for the rest of our lives.
Jim Grayway, KWCH 12, Eyewitness News.